Welcome to the weekend edition on the most controversial issue. Children are controversial in marriages when parties dispute and leave. But how does the property of a marriage get resolved? Everybody is saying, this is my property. No, this is not your property. The law in section 7 deals with the question of ownership of property. How does the law say on section 7? It says, ownership of matrimonial property vests in the spouses according to the contribution of either spouse towards its acquisition, and shall be divided between the spouses if they divorce or their marriage is otherwise dissolved. So, contribution is very key. We have dealt in episode 1 what contribution means. Now let us deal with the question of how do you divide this property in a polygamous marriage? You have been married for 15 years. You have a property spanning in Kisumu, Taita Taveta, Kwale, Lodwar, Meru, Nairobi, all over. A second wife comes in married. You have been in this marriage for 30 years. This second woman is coming in. How will the property be dealt with? Is she going to, at divorce, get these properties on equal share as the first wife who has worked all this time? Don't worry about it. Court Helicopter News has gone to the legal archives and brought you the most interesting section, section 8 of the Division for Matrimonial Properties Act, which says property rights in a polygamous marriage. Listen to what the law says. This is not Omari speaking. This is not Court Helicopter saying. It says in section 8, subsection 1, if the parties in a polygamous marriage divorce or a polygamous marriage is otherwise dissolved, they, number 1, listen, matrimonial property acquired by the man and the first wife shall be retained equally by the man and the first wife only. The first wife, now you can smile. Continue watching Court Helicopter. Of course, the property that you acquired with your man as a first wife will be retained for you and him alone. The second wife will not get anything. The toil that you worked as a first wife, that property you'll divide with your husband based on your contribution. The second wife will not even get a penny. What does the law say? It proceeds to say, if the property was acquired before the man married another wife, so that property is protected. Nyambura, furahia sasa. Najua sasa Mary, you are happy because you have been married, you have worked with this man, and for 30 years, then he has gone to work in Mombasa, or he has gone to work in Kisumu, or he has gone to work in Lodwar. He has married a second wife. That second wife will not get your property that you worked for. What does the law talk in section 8, 1b, number 2? The matrimonial property acquired by the man after the man marries another wife shall be regarded as owned by the man and the wives, taking into account any contribution made by a man and each of the wives. Section 8.1b now deals with the second wife. The property that was acquired after she has come in. Remember the first wife, you have been there for 30 years. Now this woman has come in. The property that she will get is the property after she has been married. And this property will be divided into three. The man, you the first wife, and the second lady who has come in, but also subject to the contributions of each person. Her domestic or indirect contribution, your indirect contribution, the man's indirect contribution. Number two, financial direct contribution. Each of the three of you, the law will look at how that is done. Then it says, but the parties can agree. If you agree mutually, there is no problem. Section 9 brings out this question. You are a wife who is a housewife. You are not working. You have no bank account. You have no job to ask for a loan. The bank cannot give you anything. Your contribution is indirect. How can you be protected? Imagine what Section 9 says. You can acquire interest in property by contribution. Listen to it. Where one spouse acquires property before or during the marriage, and the property acquired during the marriage does not become matrimonial property, but the other spouse makes a contribution towards the improvement of the property, the spouse who makes contribution acquires a beneficial interest in the property equal to the contribution made. What does that law mean? That house Mosee built for you. Normally men don't plant flowers. Normally men don't have a garden behind the building. Normally men are not careful on the type of paint that houses are built. Normally men don't buy cushions for the sofa sets. Normally men don't bring photos to put on the walls and the others. That aspect that you have done of decorating the home, beautifying the home, that is taken as contribution. So mama, don't think that your contribution in making the home comfortable doesn't matter. That contribution of arranging the sitting room to make it look, that contribution, for example, the fridge that your man buys is a small fridge. You come in, you buy a bigger fridge. That contribution to modernize your kitchen, you get new shelves, you get new things here. Those small annexures into the house under Section 9 will be made a contribution factor, and they are beneficial when division of property will be done. Your small contribution, which you think is small, becomes a proper contribution for the purpose of division of matrimonial property. Section 10, how do you deal with it? Your man goes and borrows money from a Shylock. You are not aware. All of a sudden, you get an auctioneer coming to get this problem. Your house must be sold. Your sofa set must be taken. Your man has gone to gambling. He has gambled and pledged the sofa set. They come for that sofa set. So the question is, can you carry liability of your wife in her pledge at the chama? Can you carry the liability of your husband after he has pledged this? What does Section 10 says? Any liability incurred by a spouse before the marriage and relating to the property shall after marriage remain the liability of a spouse who incurred it. If your man went and drank beer and swore that he will pay, but that is the night before the wedding, that will be his liability. It will not come to you. Any liability before the marriage is the liability of that person. If your wife went and took cosmetics, your wife went and took some perfumes, if your wife went and took some clothes before the marriage, you cannot be told to pay for that. It moves on to say, Section 10B, 2 says, if that liability can be justified that it was going to be part and parcel of the matrimonial property, then that liability is fine. For example, a mortgage taken by you before you got married, a mortgage the man took or the woman took for the purpose of turning that home into a matrimonial property, that mortgage becomes a liability for both of you. Section 11 raises a question. Some properties are a no-go zone. Have you built your home in an ancestral land where graves of parents, graves of great ancestors are? Can that property be available to be divided? Inherited and customary practice prohibit those areas from doing it. For example, some customs demand that a house that was built by the great-grandfather moves to the firstborn, and it moves like that. Is it available for division? It is not available for division. So what does the law say? Understand the customs of your spouse, whether those customs allow or they don't allow. That is a very, very critical question relating to that. That being very explosive, I think we should analyze that to bring it to concept. That you need to understand how the law deals with those properties before you divorce. Don't get shocked because Court Helicopter News brings you this episode every weekend. Wakili Danstan Omari finishing the second episode of Court Helicopter News all the way from the long holiday of Mazingira Day. Thank you. See you in the third episode shortly. Asante sana.